Welcome to this explainer. Okay, let's just address the elephant in the room. A sudden layoff, it hits you right in the gut. We're talking immediate stress, total confusion, and a very real, paralyzing fear about your finances. Suddenly, you're spinning, wondering about lost income, healthcare, your whole future. But here's a massive secret most people completely miss when they're drowning in that initial panic. You still have incredibly powerful legal protections, even when a company is actively slashing its workforce. So my goal for us today is super simple. We're going to take you from that paralyzing fear and move you straight into actionable empowerment. Let's get into it.
Think about this for a second. If your company announced layoffs literally tomorrow morning, would you know exactly what to sign? Or actually, scratch that, would you know what not to sign? Look, most of us just blindly accept our employer's decisions without asking a single question, right? We buy into this illusion of absolute job security, and then when the shock hits, we're just too stunned to push back. But unfortunately, that specific mistake, it can cost you serious money, vital benefits, and your legal protection.
All right, so here is our survival guide for today. First, we'll cover the reality of workforce reductions. Then, your shield against discrimination. After that, surviving the actual layoff notice, negotiating a better severance, and finally, rebuilding your financial security.
Section 1. The reality of workforce reductions. To really defend yourself, you've got to understand the corporate landscape first. You need to know the actual reasons these cuts are happening in the first place.
So why do companies actually reduce staff? Well, it's usually for operational reasons. We're talking economic downturns where dropping consumer spending forces businesses to tighten their belts. Then you've got mergers and acquisitions that suddenly create duplicate roles. Plus, there's the rapid rise of automation replacing job functions, outsourcing to external vendors to lower expenses, and just intentional corporate downsizing. And here is the absolute crucial takeaway. While businesses totally have the right to control costs and survive, they absolutely cannot just toss labor laws out the window simply because the economy took a hit. A mandate to cut costs does not overwrite your legal rights, period.
Moving right along to Section 2, your shield against discrimination. Now let's slow down here for just a second, because this is where a lot of folks feel incredibly vulnerable.
There is a very, very hard line that employers simply cannot cross. Look, it's perfectly legal for a company to eliminate an entire department because of a merger. That happens. But it is completely illegal discrimination to use a layoff as a smokescreen to target older workers, just to hire younger ones at a lower salary. Absolutely not allowed. It's also illegal to target pregnant employees, and there is no way they can use a layoff to retaliate against someone who just filed a formal workplace complaint about harassment or unsafe conditions.
These protected characteristics, age, race, gender, religion, disability, national origin, pregnancy, and sexual orientation, think of these traits as your armor. Employers are strictly forbidden from discriminatory practices related to any of these. So if you're going through a layoff and you start noticing some weird patterns like, hey, mostly older workers are being let go, or there's zero documented business reason for your specific termination, you need to act. Gather your evidence right away. Save those emails, grab your performance reviews, hoard those internal communications. Because if you need to consult an employment lawyer, organized documentation is exactly what they're going to ask for.
And beyond discrimination, you also have rights when it comes to notice. If you're based in the US, you really need to know about the WARN Act. This is a massive legal lifeline. It generally says that companies with 100 or more employees have to give you 60 days of advance notice before a mass layoff. And get this, if an employer just completely ignores this notification requirement, the affected workers might actually be entitled to back pay and benefits. They can't just slap a padlock on the doors one morning and walk away scot-free.
All right, Section 3, surviving the layoff notice. Now we are entering the danger zone, the immediate aftermath of that termination meeting. We need to bust a massive workplace myth right now. Yes, human resources coordinate the exit meetings, they explain the benefits, and yeah, they're the ones who coordinate the return of your company laptop. But make absolutely no mistake about it, HR is fundamentally there to limit the company's corporate liability. They're not acting as your personal advocate. They're protecting the company's interests first and foremost. So you must independently verify every single piece of legal and financial information they hand you.
And the physical reality of a layoff has completely shifted lately. In a traditional office, you have that super awkward in-person meeting and then you get escorted out of the building. But if you're a remote worker, wow, the reality is incredibly abrupt. You might be sitting on a virtual termination video call, and before the HR rep even finishes talking, you experience that absolute panic of your Slack account and work email just going totally dark. Boom, gone.
That sudden deactivation means you can lose access to important records, performance reviews, and payroll info in literal minutes. So remote workers, you have to be incredibly proactive about saving important documents well before your access magically disappears.
When the layoff actually hits, you need a solid strategic roadmap. Fast, organized action, not an emotional reaction, is what's going to protect your income. Step 1. Request written documentation. You want your termination letter, your benefits summary, and final paycheck details all in writing. Step 2. Do not sign a severance agreement immediately. Never, ever rush this. Take a breath. Step 3. Apply for unemployment benefits right away to reduce any financial delays. Following these specific steps is what keeps you grounded when everything else feels chaotic.
Moving to Section 4, negotiating a better severance. This brings us to honestly one of the most empowering parts of this whole explainer. We need to completely reframe how we look at severance packages. It's not some final, unquestionable decree handed down from a mountaintop. Think of it as an opening offer. Because here's the crucial point. Severance pay is rarely legally mandatory. Most people just assume it's an automatic legal right, but it's really not. Unless you have a specific union agreement, an employment contract, or a crystal clear company policy, they don't actually have to pay you a dime. So why do they do it? Well, employers offer severance voluntarily to reduce their legal risks and protect their reputation. They want you to sign away your right to sue them. And because they want that signature, guess what? You have leverage.
And because you have leverage, you have options. Welcome to the negotiation menu. If you've got a strong performance history and specialized skills, you can and should negotiate professionally. Ask for additional pay based on your years of loyalty. Request those unpaid bonuses they might have conveniently forgotten about. You can even negotiate for a guaranteed positive written reference to speed up your job hunt, or get the company to pay for professional career coaching. The bottom line? Don't let shock force you into accepting their very first offer.
Now, when you are negotiating, healthcare is absolutely paramount. If you're in the US, you have got to understand COBRA. It's a law that lets you keep your employer-sponsored healthcare for a limited time after you've been laid off. The catch, of course, is that you usually have to pay the full premium cost yourself, which can be ridiculously expensive. However, negotiating extended medical coverage or getting the employer to contribute to your COBRA premium during those severance talks, that is an amazing way to prevent dangerous and super costly gaps in your medical coverage while you transition to your next gig.
All right, final section, Section 5, rebuilding your financial security. You know your rights, you know how to handle the notice, and you know how to negotiate.
Now we secure your immediate financial lifelines. Look, chaos is terrifying right up until you categorize it into manageable timeframes. So, here is your financial survival timeline. Day 1, you do not panic. You simply create a reduced emergency budget focusing strictly on essentials. We're talking housing and groceries. Week 1, you proactively reach out to lenders if you need to, apply for unemployment, and pause all non-essential spending. Cancel those subscriptions. By month 1, the financial bleeding has stopped, and you can pivot strictly to growth, learning new digital tools, and picking up temporary or freelance work while you hunt for that permanent role.
Let's zoom out and look at how this strategy builds into the rest of your life. The reality of the modern workplace is that technology, AI, and global competition are just constantly driving restructuring trends. It never really stops. So continuous upskilling is your true shield against job instability. You future-proof yourself by expanding your professional networks long before you actually need them, learning modern digital tools, and keeping that resume fresh and updated, even when you feel completely secure in your current job.
You now have the knowledge to protect your income, to challenge unfair treatment, and to negotiate from a place of absolute power. But at the end of the day, your ultimate protection is your own adaptability. So, I'm going to leave you with this. What new skill will you learn today to future-proof your career for tomorrow? Take control of your professional future. Thank you so much for joining me on this explainer, and I'll see you next time.